Good morning, good afternoon, good evening, and welcome to today's episode in the series of Investment Mediation Insights, ICSID's webinar series providing practical information about investment mediation. ICSID's investment mediation rules were adopted by our member states in 2022, and they are different compared to other ICSID frameworks in that there is no nationality requirement and also no link to ICSID membership required in order to make use of the facilities at the Center for the Mediation. In addition, another difference of the ICSID mediation rules is that parties may submit a request for mediation that contains an offer to mediate, which the Secretariat will then transmit to the other party, inviting that party to state whether it rejects or accepts the offer. Once the offer is accepted, the registration will start and the mediation can be instituted. More information on mediation in the investment context is available in our background paper on investment mediation. We will add a link in the chat, and also our background paper on investment mediation provisions in treaties. Now, in this series, I want to draw the attention to two prior webinars that have been held in November of 2025 and December of 2025, where we debrief real investment mediations with a mediator and representatives of each party. In today's episode, we will look at amicable dispute resolution in the investment context, and I am very happy to have with me here today two panelists with extensive experience in this context. On the one hand, we have Pupak Bahimin, who is an international legal executive with over 30 years of experience practicing law, primarily in the global mining industry. Pupak's experience spans cross-border transactions, governance, and complex dispute resolutions. As a lawyer in private practice, from 2022 to 2026, Pupak then served as the general counsel of Barrick Mining Corporation, where she led the global legal function advising the company's board and management on legal, regulatory, and risk matters. In addition, Pupak was also the former chair of the World Association of Mining Lawyers. Welcome, Pupak.
Thank you.
We also have Ken with us today. Ken wears two hats. On the one hand, Ken is co-founder of a negotiation, mediation, advisory, and training organization, CMPartners. And on the other hand, Ken is the founder and executive director of a new nonprofit organization that focuses on global conflict management, but actually moving it from management to transformation. Ken used to serve as the acting undersecretary and deputy undersecretary for international trade as the U.S. Department of Commerce, and in that capacity Ken facilitated disputes between U.S. investors and foreign governments. So, a note on format for our webinar today. We will open questions in the chat, and we welcome that from our audience. We'll have an informal chat among the panelists and pick up any of these questions along the way. Now, let's get us started. Pupak, why don't we start? Why is mediation and conciliation in the context of investor-state dispute resolution really important?
Well, thanks, Farge, for having me. Very happy to be here. And to answer your question, I will say that the first thing they teach you in law school, and I'm a lawyer, obviously, so I'm coming from that angle. The first thing they teach you is that your worst settlement is better than your best day in court. And for me, 30 some odd years later of experience of practicing law, my personal view is that is absolutely true. And that is my personal view. And anything I'm going to say today is really my own personal view. It's not to be associated with any of the organizations I've been with. So that is my personal view for any dispute. Now, investor-state dispute is even harder, I would say, than regular disputes, and hence then the possibility of settling, especially having a kind of a third-party independent mediator helping you in settle, then that is definitely an opportunity that one should consider and oftentimes take. I do want to say just one word as to why, if you can give me 1 minute, as
Please.
to why the state investor dispute and arbitration, including in before exit, which is by far the best kind of is dispute forum for investments, is harder. First of all, even today, 2026, even acquiring the right to arbitration is a challenge. It's more challenging than it used to be 20 or 30 years ago. Oftentimes, as investors, we used to have access to that kind of dispute resolution mechanism through investment treaties, BITs. Those rights in the newer generation of treaties, whatever they called FIPAs or whatever, those rights are being watered down, and access to arbitration through that mechanism or that route is now oftentimes more limited. Contractually agreed arbitration is also oftentimes more difficult to negotiate. States oftentimes prefer arbitration that are regional, local, seated in their country, would not agree to certain claims, would not agree to waive immunity. So just more difficult to secure an unfettered access to arbitration. Now, even when you do have access to arbitration, having been in the room where a decision, if you are an investor with assets, operations, and especially staff, personnel on the territory of a host country, you're about to get into an arbitration, that decision is a hard decision to make. And you think twice, 10 times, 100 times before you actually launch that arbitration. And even when you do get to a point where you actually have no choice and have to launch the arbitration, between the cost of it, between the length of it, the risk of reprisal, etc., I have to say it's a very, very difficult experience. So again, just to conclude, if you do have a third party here as a mediator, conciliator, who's trusted by the party and who can help them bring together, again, an opportunity you want to take.
Mm-hmm. Thank you, Pupak, for starting us off and sharing the investor perspective. Ken, from the government side, what are your thoughts? Why is conciliation and mediation important to consider in this context?
Well, I think, as was said, the process of mediation, conciliation, facilitation enables possible solutions to emerge that might not emerge in a formal legal process. These disputes have legal issues, but there are also relational issues. There are issues of pride. There are emotional issues, and the degree to which you can create a space where a government and an investor can explore solutions, I think creates opportunity. So that's sort of one piece. The second piece is, as was said, the cost and efficiency or the inefficiency and the high cost and the length of the adjudication process in arbitration inhibits a government from showing its attractiveness as an investment destination. So the opportunity to solve these things, show that you're a government. And then finally, I would also say the relational piece to this is if you end up following through on the arbitration, the relationships get damaged, and that has negative consequences, both for this particular investor, because maybe that investor is adding value to the society. So I'd say better solutions, more creative solutions, less cost, less time, and potentially relationship maintenance, possibility for relational repair.
Mm-hmm. And you mentioned attractiveness of government, which reminds me of one thing that I omitted to mention, that you actually call it the creation of Select USA, the investment promotion agency within the United States. So thank you for that aspect, Bryn. So what are typical scenarios that you have seen in your roles that led to investor, government, investor state disputes? Pupak, do you want to start?
Sure. Look, I mean, in one word, one way or another, a form of expropriation as in nationalization. And I'm just going to focus on expropriation because it can have many faces and many shapes. But, oftentimes non-renewal of your title, if you have a mining title, whether it's an exploitation title that you're at the end of your period and you still have reserves that are not depleted and your investment is there, and then your license is not renewed, so you can have to cease operations. Sometimes even the exploration license, although obviously smaller stakes at that point, non-grant of your exploitation license. So a lot related to the license itself. And then on the one hand, and then the other category of events that often happen is a change in the terms of your operations. More often than not, your tax regime, which sometimes is stabilized, so kind of a breach of that stability, a change of the legal regime that make your operations more onerous to the point of making it not profitable anymore. Those type of situations. Otherwise, sometimes also just other breaches of a contract when you do have an investment agreement or development agreement, which is not always that kind of situation.
Thank you, Pupak. Ken, from your experience, what have you seen? What kind of disputes?
Well, everything, whether executive branch or from a legislative branch, less so from a judicial branch, at least in my experience, some change which impacts the fundamental economic bargain that was cut, the initial deal that was cut. So it can be a regulatory change. The Ministry of Energy changes a regulation which changes the underlying economic bargain. A water authority enables a new company to mine or extract resource from the same place. An executive action which slightly changes the economic bargain. So at least I saw it. I tended to think about regulatory changes, executive actions. I sometimes even saw failure to pay as an issue, where governments would withhold payment for whatever the reason was. But executive action, legislative action that changes the economic bargain. And I would tend to see them earlier than they had gone to arbitration, right? My role was to prevent the conflict, the dispute, the issue from fruiting into a suit. I was asked to help early, which we can talk about.
Which is actually a perfect segue to the next question. Given your experiences that you have seen in your roles that you have exercised on the one hand for the investor, on the other hand in the context of the government, at what point in time is settlement likely? Is it preferable to attempt and achieve it, more likely to achieve during operations, during the cooling off period, so after a notice of dispute or intent to arbitrate and actual formal proceedings being instituted, or once the request for arbitration is in, the arbitration is underway, and in the shadow of the arbitration and negotiation, or even after an award might be issued? Pupak, what's your experience if we look at this chronology of possible settlement windows?
I'm not sure there's a generalized answer to your question. It is always a case by case. I would say if you're looking at it from the point of view of the investor, it is oftentimes preferable to settle before you launch arbitration. There's a lot of risk, and I'm not even talking about the cost and the length and all of that, but there's risk. You have your assets, you have your people. You have your operations, and oftentimes if there's any risk to any of that, then that outweighs the benefits. So if you're able to settle before you launch arbitration, or even you give your notice of dispute, which it's because, and I may mention that because you kind of mentioned the cool off period. So if you can do it, and my experience of investors is that they'll do they will try to get that settled beforehand and not make it to arbitration, or not even make it to the notice of dispute. Once you did mention the cooling off period. I don't have an experience of things having been settled during that time. It doesn't mean it doesn't happen. I just don't have the experience of it. I would say off that, if your matter is serious, and it is serious, right? If you're an investor, a dispute with your host country is serious. So people try to get ahead, as Ken said, we all try to get ahead of the dispute as early as possible. So oftentimes it's either done before, or then unfortunately you kind of have to wait until, as you mentioned, the request for arbitration or notice of arbitration is given. The parties then at that point in time file their various submissions, lengthy submissions, where you kind of set out at length your position, your factual allegations, et cetera, et cetera. That sometimes motivates the parties then, whether because they go through the pain of preparing it, whether because they see the other party's, a position. That sometimes motivates the parties. I would say personally, and that's a personal thing for me, oftentimes sitting and listen and kind of having a view of the panel that has been selected. I often made a point of personally sitting through even a procedural order, because it kind of gives you a feel for the panel. That also sometimes motivates you to say, you know what, it's better to settle. So all of that, in my experience, most settlements have happened after the notice has been given and kind of some submissions have been made. And just to finish, you did mention after the post-award. The post-award, so look, I mean, I do have one experience of that, and that has happened at the company I was at, where an award was given. It was an ICSID award, and it was an ICC award, sorry. And then it was renegotiated into a different deal. But in most instances, a post-award negotiation deals with costs and things like that. So it's kind of more ancillary than substantive. Again, I'm not saying it's not happening, but that's
implementation of the
implementation of
ruling.
the award, costs, interests, things like that.
Installments, yes, we have seen that. So a lot of different windows possible, and depending on the circumstances and the actors involved. Ken, what is your experience there on the different stages for settlement opportunities?
So let me echo that which was said about tough to generalize. That being said, my experience is the earlier the better pre-filing of a suit, legal action. I always would describe it as if you could engage the topic when it was an issue before it became a problem. If it had become a problem, if you can engage the problem before it became a dispute, and if you could engage the dispute before it became a suit. And so early interactions enable, take the pressure off an official to say yes. If it's an issue, I'm resolving an issue. If it's a problem, I'm solving a problem. It's much easier for an official to say yes to the resolution of an issue, the resolution, addressing a problem, and even dealing with a dispute. So the earlier one can play, and it was at least my experience, different private sector players had stunningly different abilities to really engage governments early and inclinations to engage governments early. And as was said, sometimes for fear of reprisal, but that sometimes let the problem fester and then become more problematic. So I would lean early as possible, if you can, before the suit. Two other comments I would make. One is part of what should shape your timing is the context within which the dispute lives. And all I mean by that is that some end up following the legal procedure in its normal steps, but something changes in a country. There's an election, there's a new government. There's a government that might have an interest in showing a different face to business, right? A certain more pro-business government is elected. It's the end of an administration. I have sometimes found companies not to be sufficiently focused on the broader context within which their dispute lives. And third point I would just make is the timing issue, which is, if you simplify settlement, an organization, a company, a government is thinking about, can we agree to something, a yes, Or will we continue down our path of no, which is the legal suit? And sometimes perceptions of the possibility of a yes or the attractiveness of no shift in the parties. And so constantly asking and answering the question, do we have a different way of yes, and or are the parties seeing no differently, can sometimes create opportunities.
And to continue to have a conscious choice as to how to approach the resolution of the dispute along a particular timeline, taking into account the broader picture. We have a couple of examples of that of it in ICSID arbitrations that settled precisely with an outgoing government, for example, or actually when a new company is elected. A new administration is elected. So staying a little bit on the side of the government, what structures or organizational structures or setups are helpful from a government side to achieve settlement? The discussion often turns around focal points or lead agencies on the government side, and maybe also on the investor side. Is it the subsidiary or the parent company? Sometimes these difficulties in the organizational structures might lie on both sides. Ken, why don't you start us off?
Yeah, so I think this broader issue around how do you navigate the decision process of a government is a fundamental question here. For me, having been an official, I have the image of shaky hands, right? That signing an agreement with a company to pay tens or hundreds of millions of dollars, hands shake within the official, right? How I'm going to be criticized, the press will criticize me, I will be accused of there are all kinds of barriers to signing and agreeing. And so what structures, processes can be set up to take pressure off that official? So one, yes, single focal point agency. If that focal point is at the prime minister level, that is better than if it is in a ministry, right? Sometimes those focal points are at the Department of Commerce, not at the White House level. So single points of contact, formal structures that exist where if a dispute is raised, there's an interagency structure where it can be handled, because as you know, the Ministry of Justice might have a different perspective than the Ministry of Economy, than the Ministry of Energy. And so some kind of structure that exists. The last thing I would say is, and this goes again to the specifics of different countries, is in some countries, there is a single individual who will make this call. And it's not about an interagency process because the power is so concentrated in an individual. And so again, being thoughtful about, do I really understand the decision process? Who needs to say yes to an agreement? How would they justify an agreement? And maybe it's an informal process where what's key is access to the chief of staff, to the prime minister, versus, but as a general rule, I would say if there's some kind of structured interagency process to handle investment and investment disputes.
Mm-hmm. And looking at like the formal availability, but again, keeping the bigger picture in mind and perhaps underlying currents of political cloud that maybe need to be included in any kind of settlement discussion.
Because it's possible, I mean, Farka, it's possible again that a single set of conversations with the right individual are in fact the ways this will be moved, as opposed to getting into a formal bureaucratic process. But that really, again, comes back to, does the investor understand how to navigate the government? Because different governments are different, and they need to be thought of that way.
Thank you. Thank you. Pupak, your experience from the investor side, how to navigate, what are the structures that are helpful to achieve settlement?
I would say, and in fact, what Ken was saying was echoing with my own experience of, mapping that government, the authority, whether it's legal or actual or practical, it is a challenge. Now, if you're an investor, and I have to admit that obviously I've come from the legal side. Oftentimes, I'm not the person, it's not the legal team that does the mapping. Oftentimes, it is done by our teams in a company who are underground, right? We have a dispute because we have something going on in the country and we have people underground who assist. Sometimes we have to retain the services of external advisors, such as perhaps Ken's, and others similar to help the company, the investor, map this out. The only thing I would say is, and you're right, it really varies from country to country. In some countries, you have kind of one person, one agency that has the power. In others, it's a little bit more dispersed or difficult. What I would say is, first of all, you have to be mindful of what is the subject of what is it that led to your dispute. If your license was not renewed because there was an uprising, because the local communities were not happy with something environmental or something this or something that, you want these people involved in whatever it is you're settling, right? They need to be happy. You need your local communities involved or your landowners or whoever. If the dispute is only tax, but it's a matter of the province feels they're not getting their fair share, then you want to have your provincial authorities or state authorities, whatever that is, in addition to your maybe federal authorities or municipal authorities. So there's a little bit of that you have to do. And the other thing I would say is, look, it's difficult, like a transaction. It's more difficult to negotiate with a multi-person party, because you have to manage all the conflicting interests. And as the investor, you have to come up with something that is going to address everyone's need. But if you're able to do it, that is by far a more sustainable settlement. So that is the advice I would give.
Thank you.
And just, Brooke, if I could just add just two things. One is the idea that one also needs to include in their mapping the constituents, people in civil society, community groups, is a critical stage. And in some cases, the company actually might be able to better engage civil society than the government. Some governments are extremely good with civil society. I am working with different governments in different part of the world where their fundamental issue is they don't engage civil society terribly well. So including that, I think, is necessary. The other thing I would add, which again may not be obvious to people, it is sometimes the case that the government doesn't communicate well. Different ministries do not communicate well. There's competition at the ministerial level. Minister A doesn't like Minister B. And so part of being a thoughtful mediator, navigator, problem solver is that the company can sometimes say, I'm going to help connect certain people, right? And this is, again, much more sophisticated thinking around, we as an organization need to include in our strategy how we're going to help the government, as opposed to simply manage the government or engage the government processes. This, for me, is more sophisticated ways of getting to yes.
Thank you for that addition. And maybe that's another segue to sort of the next block of questions. What processes have you considered helpful to achieve settlement? Assuming that, processes and structures might be overlapping in terminology, but if we now look at sort of dispute settlement processes, in which process to choose, does that depend perhaps on at what point in time we are on this dispute chronology? And what are your thoughts on like formal versus informal processes? Pupak, do you want to start us off?
I think you're referring to what we call the ADR, alternative dispute resolution. There's all kind of it, but for the purposes of this discussion, we're focused on mediation, conciliation. I would say between formal, if there is a framework that is already pre-agreed somewhere, either because, you know, to have access to a form of dispute, you need to go through it, or because you've agreed it in your agreement. Oftentimes it is better because when you're already in a situation of dispute, you may have difficulty, even if you want to do that, and you may have difficulty convincing the other party to agree. There may be also some hesitations, especially in a government where I think Ken mentioned the shaking hand, what they're not sure, et cetera, et cetera. So if you have something that is pre-agreed in terms of we need to do mediation before we start arbitration, or and also a process for selecting your, because there's also that, right? You need to choose your mediator, and then you need to have some sort of framework. Is it 1 day? Is it 2 days? Is it a month? Is it like what is the timeline? Because you also, if you have to start a dispute, you want to be able to do it at some point. So that process needs to be contained. So if it's pre-agreed, to me, it's better. It is better. I don't know. I hope I've answered your question.
Absolutely, yes. And Ken, over to you on like I know you think about like formal and informal processes. What are your thoughts there on framework and what is best selected to achieve settlement?
So I guess I would say a couple things. One is that one's strategy needs to incorporate the formal and the informal. And no matter where I am in the process, I'm asking and trying to then answer, okay, there are certain formal processes which exist. If I go to the government and send them a legal letter saying I have an issue, that potentially will trigger a formal process in this particular government where a meeting will occur, and then there'll be the investment dispute advisory board, and that formal structure will begin. So I'm asking and answering the question, when, whether, is it appropriate? Do I believe it's in my interest at this moment to trigger that formal process? Because the triggering of formal processes in governments changes the players who are discussing a topic, right? Example, in commerce, I never use the word negotiate, because if I use the word negotiate, commerce would lose the mandate to resolve a business problem with a company, and the mandate would go to the US trade representative. If it went to the US trade representative, often then a formal trade dispute process would begin, and companies that were thoughtful were very strategic around how they framed the issue. So I would ask the question, how are you using, not using the formal? And then on the informal side, again, even if I'm in a formal process, how do I think about the informal? Can I use the informal? Do I make the extra effort to show up at a dinner so I have a 5-minute conversation with a minister? But I guess what I'm saying is I'm asking and answering the question, to what extent and how am I using the formal and informal, early, middle, late, with a recognition that the formal creates different impacts. The other final comment I would make is, and back to the shaky hands, is that the degree to which there is a process that enables an official not to feel sole responsibility for signing, right? So that I'm in a group and there's some structure where I get supported, again, can be very, very important, because there are personal risks that officials take to agree, right? If I agree to settle a dispute before an award, I might be criticized. And so this question around, is there an interagency process? Is there a committee to which things go, which reduces the individual liability risk of the official, I think is something where a formal process can, again, add a lot of value.
And that formal process, let me just stay on that topic for a moment. That formal process might be pre-existing within a government structure, or it might be one that is elaborated and worked on in the course of possibly negotiations between the investor and the state in a particular context. Would you say that that's possible?
Yeah, and again, if I diagnose that one of the reasons we're not settling is because the individual who is the likely decision maker is terrified to say yes, I have a new structural problem. Help officials say yes when terrified. And if that's not that's the problem I'm trying to solve, then I ask and try to then answer, okay, how might I help that individual get support within their government, right? And again, it might be I have a conversation with them, or maybe I have connectivity to a different part of the government, but I'm trying to create a process that will help that individual.
Thank you. Pupak, any reactions?
Yeah, I would just add, your process can also be agreed in your agreement, right? If you have an investment agreement, you often do. You can say prior, parties will, in good faith, engage in a mediation, and this is the process for it. I haven't seen it often. It's not very frequent. Your dispute resolution clause tends to be arbitration, direct arbitration. Sometimes you have this kind of the escalation within the company, etc., and within the government. But I haven't seen it often, but it does happen. And I think you and I actually interacted on one of those. But something to consider. Again, if it's agreed in an agreement, you have a process for choosing your mediator, it's contained in time, I think that's something that could be beneficial.
Thank you, Pupak. And sort of building on our discussion that we've just had, how to navigate the government, and possibly we mentioned a bit stakeholder analysis and stakeholder mapping, and what are your thoughts on how to engage with government agencies that may not be involved originally, but we may need them for a final settlement, because the agencies that are at the heart of the dispute, as we discussed at the beginning of the webinar, may not be the ones that you actually need to achieve the settlement. And this discrepancy needs to be navigated. And what are your thoughts on how could one engage with that? Pupak, do you want to start us?
I don't know if I'm the right person. Maybe Ken has more experience on something like that. I think, when you do want to settle, you find a way of engaging with the right people. You obviously, again, if you're an investor, you have assets and personnel on the ground. They usually are the best people. They already are relationships in place, and so they help you with the mapping and the engagement. Sometimes, it's a question of individuals, and it may just not work. But
involve the individuals that were involved at the dispute. And I know you and I had discussed previously, if there are numerous counterparts, if you make the foundation broader, the chances for sustainability of an outcome are greater.
I absolutely believe in that. So a wider range, even if it takes longer oftentimes to negotiate with more stakeholders, a wider range of stakeholders, it's more complicated, but it is more sustainable. And so I really believe that, also depending on the nature, and I think Ken mentioned also civil society, local communities, oftentimes they need to be involved.
Thank you, Pupak. Ken, over to you.
Yeah, I would just say to do rigorous, comprehensive, broad stakeholder analysis. I have seen people who don't really do it very well. Well, there's the ministry of this, the ministry of that, this minister, that minister, right? As opposed to saying, all right, within the government, I'm going to look at the agency out of which the conflict or dispute has arisen. I'm going to look at the Ministry of Justice. I'm going to look at the Ministry of Commerce. I'm going to look at the Investment Attraction Agency. I'm going to look at the White House. I'm going to identify specific individuals. I'm going to add the legislature to it, right? Because there could be local Congress people who are involved. I'm going to add civil society. And then I'm going to do a rigorous analysis of what do they care about? What are the interests of these different players? How do they see no? Do they like no? Because some people like no. They use it as a political way of keeping things going. And then to try to be reasonably sophisticated as to understanding what is a possible decision process, as long as I also do not conclude that I know the decision process or even that the government knows the decision process. I love people who allege a decision process which actually does not exist, because the government actually hasn't faced it, but then all these people stand up and say, well, clearly this is the decision maker. It is sometimes the case that there is not a clear decision process, which again comes to very good stakeholder mapping. And then again, once one does that and really has a very detailed understanding, then I think, as was said, you can begin building now a strategy. All right, how do I engage different people at different times? And then the last thing I would just say on this whole thing, and this maybe goes a little bit to conflict prevention, dispute prevention, is if you only invest in relationship building at the time of a problem, you have less leverage when you have a problem. So spending time as an investor, engaging different players, building different relationships, if something then occurs, you have multiple people to go to with whom you've built some relationship, as opposed to the first time you have a conversation with someone is, I'm here to discuss this horrific thing that you've done. And there's less room to move than if what I've been thoughtful about is, how do I build my relationships with the government, with the communities as I engage, because that helps me if an issue arises.
Mm-hmm. Mm-hmm. And to be strategic about the analysis of who are the stakeholders, go deeper in what are their interests, what are their structures or thoughts, and then build a process around that and approach a strategy. Pupak, I'm sure you have seen that in practice as well.
Yeah, that's absolutely all the time, right? And thankfully, you know, in an organization, you will have people who already have. And first of all, I have to say, your relationship needs to be built way before you start investing, and then maintained through your investment process. Now, sometimes if you are in a dispute, it's because there has been somewhere a breakdown of that relationship. And as an organization, sometimes you see it's coming, sometimes you kind of didn't see it coming. And so sometimes you need to repair that. And so sometimes you need to put somebody else on your side to be able to repair a relationship that has not, that was not maintained properly. That does happen as well. Of course, this is all like all the prevention of disputes, right? Now, once you are in a dispute, then from the point of view of the company, you also have to choose who are the people you're going to send to actually engage. And sometimes it needs to be somebody else than the person who's been there, to take the pressure off the individuals who have been engaging or actually lived in the country. Sometimes you just bring a new face that actually matters. So yeah, that is the way you would approach it from on top of your mapping and deciding and all of that. That is also one consideration you would have from an investor point of view.
Mm-hmm. Thank you, Pupak. Very practical guidance. Yeah, and Ken, I know that you actually taught executives and students negotiation techniques. So, why can you help us a little bit? What are basic negotiation techniques you would recommend for counsel and government officials to achieve settlement in the investment context?
Well, I don't know that I would say anything other than the basics, right? That I should prepare as we've been talking, right? And that preparation is mapping stakeholders, and it is identifying the interests of the various parties, and it's seeing if I can brainstorm options and thinking about how to justify a settlement. What are benchmark or fairness arguments that would enable an official to say yes and announce in a press conference, and look at the alternatives. And so good prep. And then, as we've been talking, to think architecturally about what is the right process. Think as a process or a negotiation architect. I'm going to use this formal process. I'm going to engage this person before that person. I'm going to try to build some kind of coalition supporting me, but think architecturally. And then I think, as was said, when I come to the table, can I bring a problem-solving approach rather than a fighting approach when I come to the table? So I think sort of basic good negotiation strategies. And then, so I prepare, I architect, I engage productively, and some people learn as they go. Some people don't learn. And these disputes often last for years. And I've been shocked at the degree to which, if you ask sometimes people, so what have you learned about what the other side cares about, and how has it shifted your strategy? You do not have enough course correction, learning, shifting approaches. So prep, very proactive, and then sort of learn as you go.
Mm-hmm. And debrief
and debrief, right?
Exactly.
Yeah, that's sort of last
Yeah,
two.
yeah. Thank you both. So we're coming to the final question of the webinar as we're nearing the end. What is your recommendations for practitioners in this space to achieve settlement in investor-state disputes? Hoopak, do you want to start? One final word?
I feel we've said it all. I feel we've said it all. So the only thing maybe just as a conclusion, I would say if you're an investor, you have to just keep in mind your relationship with your host state is a long-term relationship. It's a long-term marriage here, especially in the mining sector, because, it's never a 2-year project, but in many other sectors, you're going in for a long time. You're putting your investment upfront, a lot of it, and then you need to be able to remain there for a long time to have a return on that investment, which is what, companies do. So it's long-term. Think about it from the beginning. Good faith, transparency always helps in negotiating a deal that is sustainable, and then in kind of maintaining it all through for it to pass or sustain the test of time, and changing governments, and also changing your own management, right? Because management in companies change as well. So that would be my final.
Thank you.
Keep that in your mind.
Absolutely. Thank you. Ken, recommendations from you.
So I guess I agree that we've said a lot of that which should be said. I guess the final two comments I would have is really, really put yourself in the shoes of the other party as you engage. And then maybe even think like a mediator, even if there is no mediator, right? Some people are so focused on getting their side that they don't do a good enough job saying, if I were a third party here, if I were a mediator, here's how I would approach it. So, of course, everyone will do a good job fighting for themselves. Add, okay, if I were they, and if I were a third party helping mediate, what might I do? Because sometimes great negotiators are great mediators at the same time. So that'd be maybe my final thought.
Perspective taking and broadening that mindset. It strikes me that a lot what we talked about today also relates to mindset of problem solving rather than fighting for positions. So that leads me to thank you both. Thank you both for joining us today and sharing your experiences and insights from the government side and from the investor side. And that concludes today's episode of the Investment Mediation Insights. And we look forward to welcoming you, our audience, again in our next episodes that will air sometime in the fall of 2026. Thank you and goodbye.
Thank you.